Microphone. Call the meeting back to order. I'm going to reverse the order of the two public hearings that we have this evening. We expect that one of them may have a lengthy discussion and one may be quite short. And so, Dave, if you don't mind presenting ordinance amendment number 2023-01.
Excuse me while I get through this here. So as the chair just mentioned, we are reversing, this is tab item B, but we're going to do this one first. And this was the ordinance amendment 2023-01. It's initiated by Kevin R. Honeycutt. Its request is for the purpose of amending Article 15, Section 15-24.1, accessory structure total number limitation, and Section 15-24.2. That's the accessory structure square footage limitation of the Middlesex County zoning ordinance. The amendment would exempt swimming pools, their adjoining decking and related equipment from these two requirements. Here again, this is basically just reiteration of what we had there. As the section is currently adopted, a property owner can place an accessory structure on a lot adjoining or directly across the street or right away from the lot with the primary structure present, provided they meet the requirements and a deed covenant is recorded at the clerk's office. The ordinance does not permit accessory structures such as sheds, garages, or pools on vacant lots without first having a primary structure. This has been a big topic of conversation. The reason for this is basically just basic zoning. You can't have an accessory use without a primary use. And of course, there's the fear that some of these little sheds and these little structures that people may put on a lot, a vacant lot, end up kind of having nefarious type activity. Sometimes the little shed, ends up being a house, and you have all kinds of bad stuff happen. So anyway, a building and zoning permit application was submitted for a pool on the lot directly across the right of way from the lot with the primary structure by the contractor representing the applicant. During the review of the application, it was noted that an accessory structure currently located on the lot directly across from the right of way from the lot with the primary structure. Being that an accessory structure was already present, addition of a pool would exceed the allowable structure number and structure square footage provision in this section. With the ordinance provisions currently in force, the applicant's only option was apply for an amendment or forced to be applied for a Chesapeake Bay Act exception from the Board of Zoning Appeals. This has become quite common, people applying. We have a large number of exceptions. If we can find any type of mechanism that would reduce those exception requests, that would be to our advantage probably. Our ordinance committee met on January 4th to review the proposed revisions. It was a consensus of the committee that adding a swimming pool would not create an undesirable use or would be consistent with the intent of the ordinance. It was their determination that the exemption for pools was reasonable and should be added without any conditions other than the one that's already in play. This is the draft language. It's very simple. It's actually provided by the applicant. The swimming pools and their adjoining decking and accompanying equipment would be exempt from the accessory structure number limitation. And that additional same condition placed on the gross square footage. When you look at the square footage, it's nobody I think looks at the square footage of a pool anyway, except if it's impervious in the buffer or something of that nature. So this is the rest of the language of that particular section. You can see 3B is the recording of the memorandum of understanding or the deed covenant. That's still going to be in place for this particular situation. Nothing exempts that particular provision. And this is the rest of the provision of the of that particular section, just as it's written now. Staff recommends approval of ordinance amendment 2023-01. Planning Commission voted 8-0 with 1 abstention and 2 absent to recommend approval of ordinance amendment 2023 as submitted. And with that, Mr. Chairman, I'm going to turn it over to the applicant. I believe they might want to speak in their behalf. So.
Good evening, Mr. Chairman, members of the board. My name is Kevin Hennekens. I live at 171 Rivers Edge Lane in Saluda. We bought this property in 2002. It was a vacation property for many years. In 2014, we renovated the house, and it's now our primary residence, and we are residents of Middlesex County and have been permanent residents since 2014. We wanted to put a pool on the property. Now, the properties are, we've always thought it was sort of like one property, but there's a driveway that goes in the middle. They're actually 2 separate lots. But the property's been in common ownership for over 30 years. And it was sold to us together. It was sold to the owner prior to us together and such. And in fact, you know, the garage was already on the adjoining property, if you will. When we bought the property, there was no deed covenant or restriction at that time. And when we bought it, in any event, we wanted to put a pool on it, and that would have been now a second accessory structure. And so what we wanted to do is to amend the ordinance so that a swimming pool wouldn't be classified as an accessory structure, so that we could put a pool in on the property. So that's what I'm asking you to do today. The lots, as I said, have been joined for a long time. You couldn't sell one without the other. The septic system is on one of the adjoining lot. The well is on the adjoining lot, you know, as is the garage. They're all one in the same. And so it just makes sense. And we wanted to put the pool back away from the river as opposed to in front of the house on the river. And that would, as Mr. Kretz said, allow us to avoid implications of the Chesapeake Bay Act. So, and we've agreed, you know, to the deed covenant. We will give the deed covenant. It shouldn't be ever sold separately at all. So that's what we're asking for tonight. I'd be more than happy to answer any questions that any of you may have of me.
Any questions?
Thank you for allowing me to speak with you this evening.
Sure. Thank you.
Mr. Chairman, I did have one question if I had a moment.
Yep, go ahead.
Just wondering, did the applicant ever think about just vacating the lot line? Seems to be a lot easier if the 2 lots aren't going to be sold, you know, separately.
Yes. May I speak, Mr. Chairman? Yes, that was the first thing I asked to do. And the problem is that the driveway that goes through is actually a right-of-way that separates the 2 lots. And so the lots were never touching each other technically, so that we couldn't just vacate the lot line. And so that was the problem that we had with that. That was the first thing I tried to do.
And just for
I thought we had allowed that before with the use of a tie line.
So I don't technically own the right of way. I think the county technically owns that right of way. When I went back and did a search, title search, I found a deed that conveyed that right of way to the county. So that was so that the 2 lots were not technically adjoining and there was not a lot line to vacate. I don't know how you've ever done it in the past. I apologize. I don't know the answer to that question.
Yeah, and I apologize to you too, sir. I should introduce myself. I'm not there tonight. But we have allowed, I thought, boundary line adjustments by town line, boundary line vacations with use of a tie line. What it does is it ties the properties across the right of way together. But it's 6 one way, half dozen the other if you're approved tonight.
All I really want to do is put in a swimming pool.
Yeah, roger that.
Any other questions of me? Okay, thank you once again.
All right, thank you. I will open the floor for public comment. Anyone wish to speak regarding this matter?
Is the public comment just on this issue or all?
Just on this
everything
issue,
is?
just on this issue right now.
Just on the what?
It's just on this issue.
Oh, okay.
There being no one interested in speaking about this matter, I'll close the public comment for this and open the floor for discussion among the Board of Supervisors.
Well, like I said, I don't have any more to say about that, but I would like to make a motion on it. I mean, these are certain things that we have done in the past. So if any other board supervisors don't have any other questions, I would like to make a motion that the ordinance amendment 2023-01 that we approve.
Second.
Motion by Mr. Jesse, second by Mr. Williams. Any further discussion?
Yeah, I have just a question or two, as usual. If I'm looking at the plat correctly, the road in question between the two pieces of property is Rivers Edge Lane, is that correct?
Yes, Mr. Harris, it's Rivers Edge Lane that goes right there. And the address of the property then is 171 Rivers Edge Lane. There's only one address for both of the properties.
Okay, and are there other properties left or right of lot 5 and lot 10?
Oh, yes, we have a nice neighborhood. And so that road is used by my neighbors. We maintain the road. It's just a little gravel road. And, and like I said, I've got some anxious neighbors that would like to have a swimming pool too.
Okay, and that right of way is allowed for them to be able to get to either property on either side of you.
Oh, yes.
Is that correct?
Yes, sir.
Okay. And the pool is going to go on lot 10A?
That's the one that's got the garage on it. Yes, sir.
Correct?
Yes.
Okay. All right. Just wanted to clear that up from the drawings. Make sure I was on the same page with that. I'm not quite sure where Rivers Edge Lane, but sometime before next week, I'm gonna drive down and look at it just to make sure I know where it is.
Please come, and I think
will.
you'll like it. It's right at the edge of Edgewater Lane Road. If you go
Okay.
past Christ Church, it's in the very next road. You come to Edgewater, you go down to the end. If you get to the river, you've gone too far. You turn right on the gravel road, and that's where we are.
Cool. Thank you.
Thank you, sir.
Any other questions or discussion? Have a roll call, please.
Mr. Coons,
Aye.
Mr. Harris,
Aye.
Mr. Williams,
Uh,
Mr. Jesse,
Aye.
Mr. Kimbrough.
Aye. Motion carries. Thank you.
Thank you very much.
All right, Dave. Ordinance Amendment 2022-02.
Yeah, this one will be a little bit more lengthy, I think. I'm just going through all these provisions is going to take a little bit of time. I'll try to explain it as we go. This is ordinance amendment 2022-02. It's initiated by the Middlesex County Planning Commission. The request is for the purpose of amending Article 15, Section 15-29. and that's the tourist home section. Article 22, section 22-1, the definitions, and any section that references the use tourist home of the Middlesex County zoning ordinance. The amendment proposes to rename the tourist home section to short-term rentals and add additional requirements related to zoning approval. The definition section will be amended to add definitions for short-term rentals and short-term rental operator. And the term tourist home will be replaced by the term short-term rental in the district permitted uses that allow them. This amendment and review was initiated by the Planning Commission, but it was basically done at the direction of the Board of Supervisors, and it was in response to citizen concerns being relayed to the board regarding properties being utilized for short-term rentals. We do have a current tourist home section, tourist home, which basically synonymous with what we're doing now, which regulates short-term rental of residential homes, and that's been in force since July 2018. So just a little quick background. Prior to that, we had made the determination that tourist homes or short-term rentals or Airbnbs, whatever you want to call them, were not a permitted use pursuant to the ordinance. So in response to that, we drafted an ordinance at that time and installed it in 2018. If any of the board, some of the board members may remember back at that time, we had very little citizen input at that time. So we were kind of wandering around in the dark a little bit. We were probably one of the earliest ones to install any type of ordinance that addressed this. So the fact that we had something in place to try to regulate it was, we were doing ours the same time counties like Henrico and other these larger counties were getting in front of it. So I think we were responsive at that time. It's just, there wasn't a lot to go on. We didn't have any guidelines. We didn't have any baselines as to how these things were being operated. So in response, when we put this ordinance together, Heather and Mark and I did we put the research together, and I kind of put their thoughts together, and I put together what I thought I was hearing from citizens and the board, and tried to walk the tightrope and try to create something that is amenable to our citizens and something that the board would be amenable to, and something that would give the citizens some type of venue, some type of way to issue complaints, and a way we could regulate these things in a manner that's, we could try to deter any type of nonsense or whatever's going on in these uses. So I'm just going to read through this, and hopefully it's not too wordy, but I think we need to read through it and everybody understand what we have. So all short-term rentals require issuance of a zoning permit and proper registration of the use with the Middlesex County Department of Planning. The following requirements shall apply to all short-term rentals in Middlesex County. Number one, a zoning permit shall be applied for and obtained prior to the commencement of a short-term rental. Now that's in place now. That's similar to what we have now. In addition to a completed application, the owner or operator shall submit the following supplemental documents listed in the subsections A to D below. Subsection A, as part of this application, the owner operator shall provide official documentation from the Virginia Department of Health depicting the maximum number of allowable bedrooms and any use restrictions associated with the permit. Dwelling occupancy shall conform to the VDH requirements for the number of bedrooms. If the request exceeds 5 bedrooms, the owner operator shall comply with the use group requirements as determined by the building official. That number of bedrooms trips it into another use group, which brings stiffer building code requirements. In addition to the VDH documentation, if on-site sewage disposal was utilized, the applicant shall provide proof in the form of receipt from a licensed pump out contractor that the on-site sewage disposal system has been pumped in accordance with the 5-year pump out requirements specified in Article 5A or Section 4A, 4A 10.G.1 the Middlesex County zoning ordinance or any successor regulatory agency who is going to be the Virginia Department of Health shortly, as assigned by the Code of Virginia, which is going to be Department of Health soon, we hope. The owner operator shall not exceed the limit specified in the VDH permit. In the event that the dwelling is currently utilizing a municipal or central system, only the number of bedrooms that were permitted through the building and zoning permit process shall be allowed for occupation. So that last sentence I'm going to basically expand on. That was added as a result of some of the communications we had with the Planning Commission and some of the, which was brought up afterwards. Currently, I don't believe we have any sewer, any residential structures on sewer, but that may change soon. So we know the ones we do have are in Kilmer's Point and Cedar Point, I believe, or those are the only ones. So again, and there's some citizens in that particular area that have been concerned about this particular use. So we would, when they come in to get a permit or zoning permit, we would try to verify their number of bedrooms through our whatever method we have in-house possible to try to determine what they're allowable to, because their usage may be not tied to bedrooms through their sewer system. It's a municipal system or a central. So we would evaluate through the building official. So you can see we've tightened up this. This was basically in response to citizens being worried. This does two things. It kind of controls the number of people that are in the house, because if they have a 2-bedroom or a 3-bed, let's say a 2-bedroom septic, and they're advertising the house as a 6-bedroom, then that's a zoning violation. And that's what we're seeing a lot of. We're seeing a lot of homes that are being overused. They are advertising more bedrooms than which has been permitted. And that probably correlates with health department approval, because if they had additional bedrooms, that would be in conjunction with one of our processes. So they're probably in violation of their Department of Health standards too. So this would serve to limit the number of people in the house. And it also helps relieve some of the concerns that people may have with the overuse, where you have a sewage system failure, where you're overuse. So that was one component. Subsection B, the owner operator shall provide complete contact information, which shall include but not be limited to a current phone number, an email address, a current address of a party responsible for management of the use. The responsible party, contact information shall be provided via certified mail by the owner operator to the property owners that adjoin the use and are located across the right-of-way of the property, subject to these requirements. The planning department will provide a distribution list of the adjoining property owners in a form letter to the applicant once application has been made. If the management entity or any contact information changes or the use has been discontinued, the Middlesex County Planning Department and adjoining property owners shall be immediately notified. So what this does is it gives the owners will have the contact information for a party responsible. So if somebody's acting out, somebody's out there at 3 o'clock in the morning, they're noisy, somebody pick up they'll have that number. They can pick up that phone and call, hey, those people you rented the house to are acting inappropriately. Now, there's another section that, whether or not I've discussed it, we added, it's in the recommendations that could be added into this if the board so chooses. So I'll show you that at the end in our recommendations. This is not too much different than what we had before. We required adequate off-street parking. That's always been in the ordinance, but we've expanded on that some. Adequate off-street parking shall be provided for all vehicles, which shall include but not limited to cars, trucks, boats, jet skis, and recreational vehicles. Originally it was just for cars, but we've added in the Planning Commission through conversation, thought that these and hearing some citizen concerns, added in all these other types of vehicles, which could, a lot of times people could park their cars in the driveway, but they're parking their boats up and down the street. So you have to find place on your property. You can't utilize your neighbor's property for your parking needs. It just doesn't work that way. One parking space for each sleeping room shall be provided and shall not be located in a required front yard except within an existing driveway that's already there. On-street parking shall not be utilized to meet the requirements of this section. This is fairly basic. It's just safety oriented. An evacuation plan shall be submitted with the application that depicts all egress points of the dwelling. In addition to the evacuation plan, the applicant shall be required to maintain a type 2A 10 BC fire extinguisher in the kitchen area and indicate the location on the provided plans. Once the application has been approved, the owner operator shall display the evacuation plan in a conspicuous location in the dwelling. I think it's building code now that you have to have a fire extinguisher underneath your sink or something. It's part of the inspection process. So that's just current code, and it's probably just an extra safety measure for these. We're going to number 2. The director of planning or zoning administrator may, if determined necessary, require screening on or generally along the property line with the adjoining property. This screening may be fencing or vegetation that achieves the same screening component as fencing. This is probably not going to be used too often. We haven't used it to date. So this provision was in the original language that we had. It's been modified to just clean it up a little bit. Unless there's some unusual circumstance, more than likely, you're not going to see us specify fencing or screening. Most of the time people have natural screening. There's something there that can block it. It would have to be some type of mitigating circumstance, like somebody's packed right on where it's going to be an obvious, nuisance to somebody. But generally we haven't exercised that, but we do have the ability. I left it in there so we can if we have to. So this is something that's been talked about. The use shall not generate any additional noise, light, or traffic than would usually be present or associated with adjoining properties or other properties in the zoning district. So if somebody's got something and have a use and they have 30 cars running up and down every 10 minutes, that probably doesn't meet that component. I think we need to address it, probably send them a letter as to, hey, what's going on here? That would probably indicate something more nefarious than just a residential use, but that is in there to protect the property owners around it. No signage advertising short-term rental shall be permitted at the property. Establishment of a short-term rental in the general business and light industrial zoning district shall only be permitted in an existing dwelling. Single-family dwellings aren't permitted in this district. So you wouldn't want to negate somebody to be able to do this if they have legal non-conforming, but you wouldn't want to create a use that wouldn't be otherwise permitted. Number 6, no short-term rental shall be allowed in a dwelling unit established for workforce housing as defined herein. I don't think we're going to want to subsidize somebody's housing so they can rent it out so that and make money on it. That's kind of a no-brainer probably. This is the component that deals with enforcement. So you can see this is rather wordy, and Heather's probably going to have some comments. I'm going to turn to her to, she can explain some of the nuances of this, is because a lot of them deal with how things are enforced, how you go to court, and what happens with fines. So I'll go through this. The use shall be operated in compliance with all conditions referenced in the section stated above. If a short-term rental has 2 or more substantiated complaints, and that 2 was a planning commission recommendation, it went from 3 to 2. The planning commission recommended that reduction in the number of complaints, including but not limited to noise, trash, or parking within a 12-month period. The operator's zoning permit may be suspended or revoked Before any suspension or revocation can be effective, the zoning administrator or his designee shall give written notice to the owner operator of the short-term rental. The notice shall contain the following: A description of the violation constituting the basis of the suspension or revocation. If applicable, a statement of acts necessary to correct the violation, a statement that if no written response is received by the zoning administrator or his designee within 14 days from the date of notice, the zoning permit will be suspended or revoked. It shall be unlawful to operate a short-term rental, 1, without first obtaining a zoning permit. 2, if you have not obtained a business license from the Commissioner of Revenue's office, or your business license has been suspended or revoked. And 3, with any other requirement in this article. Any person, firm, or corporation, whether as principal, agent, employed, or otherwise, violating, causing, or permitting the violation of the provisions in section 1529 of the ordinance shall be guilty of a misdemeanor, and upon conviction thereof shall be fined not less than $500. You can see we've added these definitions. They're right out of the state code of Virginia. Short-term rental means provision of a room or space that is suitable or intended for occupancy for dwelling, sleeping, or lodging purposes for a period of fewer than 30 consecutive days in exchange for a charge for the occupancy. The term tourist home, where used in this ordinance, shall be deemed synonymous with short-term rentals. We've added the term short-term rental operator, means the proprietor of any dwelling, lodging, or sleeping accommodation offered as short-term rental, whether in the capacity of owner, leasee, subleasee, mortgagee in possession, licensee, or any other possessory capacity. This particular section, I put this in here, this is the tourist home section as it's written. So you can see we do have some provisions. It required a zoning permit and a sketch. Off-street parking was a component. Also the screening requirements if needed. And the use shall not generate any noise, light, or traffic that would usually be present or associated with adjoining properties, other properties in the zoning district. So up to this date, it's a permitted use, but we have had some regulations in place that we currently go by. Staff recommends approval of ordinance amendment 2022-02 with the following addition. This may be something the board wants to consider. In subsection B, require the party responsible for the management of the use to respond and attempt to resolve any complaints within 30 minutes of being contacted. This puts further onus on the operator to respond. They probably you'll see more and more of these operators probably delegate this to an agent, some type of agent, whether it be a real estate agent or some type of management agent. That's probably the best way to do it. You can current state. There was legislation in this particular session, General Assembly session, that where there was something on the table for consideration where I guess a lot of localities have been a little overly strict on this particular ordinance, and the industry lobbied against it. And that lobby will continue against some of these localities that put very strict restrictions on these uses, or go as far as to not allow them at all. So it was tabled this year, but I would expect, and Ms. Lewis will probably concur, you're going to see this come up because this industry is big, and as soon as we say we can't do it, somebody's going to make a law that says you have to, probably more than likely. They haven't done it yet, but I would say the pressure will mount with the General Assembly to push and try to balance this thing out, where localities will, still have the ability to regulate it, but not overly regulate it. So, and I think this ordinance as written kind of straddles that fence. I think we've tried the best we can to try to project something that's reasonable, allows the people use and still gives our citizens some protection. Planning Commission recommendation, the Planning Commission voted 8-0 with 1 abstention and 2 absent to recommend approval of ordinance amendment 2022-03 as submitted with the following revisions. Expand the vehicle definition by expanding the term vehicle to include cars, trucks, boats, trailers, jet skis, and recreational vehicles. And the second one is reduce the number of complaints from 3 to 2 that would constitute a violation. So with that, Mr. Chairman, I don't think I have anything else to add. I'm going to turn it over to you, and I guess we have some citizens here that would like
Just
speak
one
for-
clarification, Dave. When you
Yes.
read this recommended addition, I think you misread 60 minutes as 30 minutes. That's what I heard anyway.
Did I say 30 minutes? Oh, I'm sorry. It's
So just want to make sure that it's
Oh, I
clear. It should be
appreciate that.
60 minutes.
It's 60 minutes. Yeah, that's what it says. I apologize for that. So with that, I turn it over to the chair to open up public hearing.
Okay,
If there are no further questions.
we may have some later, but so what I'm going to do is I'm going to just read the general requirements for public comment. So I don't recognize folks and you may not understand. Hold your seat. So these are the requirements for public speaking at this forum. Each speaker will give their name and address for the record. Each person will be given 1 opportunity to speak. All comments need to be made to the Board of Supervisors, not to the audience. And there is allowed 3 minutes, correct? 3 minutes for each speaker. So I'll open the floor for public comment. And please, is our microphone on the podium? Do we know? Okay, great. So welcome.
How y'all doing this evening? I want to thank the supervisors for what they try to do for the county and all that stuff. It's a tireless effort. You got to try to juggle now and in the future. But on the screening request for the short-term rentals, there's a couple of factors that haven't taken into when the short-term tenants allow pets and they're chasing neighbors, dogs, people walking on the street, all of that. I guess that would fall under the complaint department. If the animals are doing such, we have run into this situation before. And when all of the adjoining residents who are full-time residents have asked for screening and the county just turns their back on them, it's not fair to the full-time residents of this county. And I know the county is looking for as much funding as they can get. Some of this comes from Richmond, but everybody here lives in this county. And if it happens 130 feet from your bedroom, you would like to have some screening. And I think the county should look at if all the residents require that or are asking for that, that screening be provided. One person is everybody should be able to do what they want to with their property, but when it affects other people's property, there should be some I got nervous.
I'll back you up. We need your name and address for the record. So maybe you can,
Did I give the name and address?
Yeah.
Oh, I did not. John Moorcock, 39 Finn Street, Deltaville, Virginia. I wrote it right at the top of my letter. I just jumped ahead of it. But I think more consideration should be given to the residents of these neighborhoods with the short-term rentals. And I don't think the county has given that to the property owners down there. That's about all I have to say. Thank you.
All right, Mr. Scott, is that- Thank you. Would anybody else like to address the board?
Do what?
Just, anybody else?
Yes, sir.
Come right ahead, just give. us
You
your
need
name
that
and
for the
address,
record.
Please.
Chris Hodge, 73 Sturgeon Street, Deltaville. And thank y'all for y'all's subject on this tonight. One question is, I know when I came to the commission's meeting, you could get up here and ask questions, but they didn't want to answer them. They didn't answer them at the time. Do y'all answer? No.
It's an oxymoron to say this, but no, we don't answer.
So when does like me get an answer to my question?
Mr. Chairman, would it be helpful for us to weigh in just briefly? I don't want to
Yeah.
take away from his time.
Yeah, that would
We'll
be
still let
fine.
you continue to speak.
Yeah.
So the board can choose to answer the questions during their discussion time or they would most likely direct you to talk to Dave Kretz, the zoning administrator, or the county administrator's office, depending on the questions. Just that's how we typically do it procedurally.
Okay,
Okay.
'cause I know last time
The
I
planning
wasn't
commission-
given that information.
Yes, sir. And I understand that frustration. I apologize to that end, but yeah, that's the typical process.
Okay, then,
So you're welcome to express them during your public comment period, and then if the board wishes, they may discuss it during their time. But if not, then you would want to follow up with Mr. Kretz, absolutely.
all right, because I'll go ahead and bring up what I brought up last time. One issue was the pets, which y'all heard about tonight, where they basically, they'll run in the neighbors' yards, chase cars, chase people walking down. And when I say chase, I don't mean they're violent dogs. They're probably more friendly and curious, but they do that. My other question was, once it becomes a Airbnb or short-term rental, is a short-term rental only when they have guests? Was a short-term rental basically at all times? And the reason I'm asking that is because you should have certain rules of a short-term rental, but the owners basically would do opposite of rules, I guess, they demand with the short-term rentals. So does the same rules apply to the owners as the short-term rentals at all times, or when they go home, the short-term rentals go home, does all rules go out the window? I take it nobody's gonna discuss that with me now. Is that right?
Procedurally, that's correct. Yes, sir. This is time for you to talk, and I have instructed them as their counsel, this is really not appropriate. We want to hear from the public, and then it's not a back and forth.
Okay, could I get that name in writing and a phone number that I can?
Yes, sir. I got you. I'll write it down for you.
And the board may ask.
Okay, because I mean, I feel like me as a resident, I'm wasting my time coming up here if I'm not gonna get an answer. I know I've heard that from some other people. But anyway, thank y'all very much.
Thank you, Chris.
Can I approach?
Yes.
Okay. I'm William Dowd, 115 Sturgeon Street, Deltaville. I was also at the Planning Commission and I had the same question about questions. So now I know you don't get answers unless you follow up. So, but the one question I did ask at the last meeting was whether if this is passed, does everyone have to reapply for a permit? Or if you have a permit, do you just get to keep it and you don't have to comply? Nobody answered that question, but maybe you want to think about that. The next two questions came up just listening to the presentations tonight and looking at the revised ordinance, because it seems like there's a restriction there on advertising the number of bedrooms based on septic permits and things like that, but it doesn't restrict the number of people. So I've seen 3-bedroom houses listed for sleeps 14. Okay, how do you handle that? Maybe you should limit the number of people in addition to the number of bedrooms or based on the number of bedrooms. The other thing I saw was the one parking space for each sleeping room, I believe. But that doesn't mean you can't have 12 other cars. You only have to have 3 spaces if you have a 3-bedroom house, but you could have 14 vehicles, right? So maybe you should limit the number of vehicles based on the number of spaces. Just some suggestions. And then last was just an observation I had from a real estate listing in our neighborhood just this weekend that says they're advertising a house for sale, and the listing itself says there are no local Airbnb restrictions in Middlesex County. So I can tell you who the realtor is. I don't want to tell you that in public. I don't want to have them to lose their license, but I have a feeling that probably happens a lot. Okay, so people don't know, even if the rules are vague, they act like there aren't any rules. So anyway, those are my thoughts, and I appreciate your time.
Thank you, Mr. Dow. Anyone else? All right. I'll close the public comment period and open the floor for discussion. And I think some good questions have been floated and that it would be very constructive. Dave?
I can answer. Yeah, I can answer. I think Heather's written them down. I'll take them in order. I think the first one dealt with animals. I believe so. Running wild. Our ordinance doesn't have any power over animals per se. We have, if you're having trouble with any type of dogs or animals, I think they beefed up our animal control portion of it's now over with the police department. If these animals are, I guess, nuisance, you can always call the police department. I guess that would be the proper avenue for that. It's outside of our, the realm of our ability within a zoning ordinance. The only thing our zoning ordinance deals with is agricultural animals and residential zones, but it doesn't regulate dogs unless they're in a kennel. So, but just regular people having a dog and running around, it doesn't really address that. So,
Because the only other option there would be, Mr. Chairman, as you know, individual subdivisions have, for example, I think Yankton Shores has adopted a leash law. We do not have a leash law in this county. And so because we do not have that, when a dog is running loose, we're limited. Now, if the dog is acting aggressive and is chasing people from walking, whether they intend to bite or not, but just being aggressive generally, that would be very appropriate for the sheriff's office to be called, and they'll assist as they may. But short of adopting a leash law either in the whole county or within that individual subdivision, zoning doesn't have the legal remedies to address those concerns. But if I may, that was one of the reasons Dave and I recommended that added language about contacting the owner. And maybe it's not technically a violation of the zoning ordinance, but staff, we were thinking, if you can then call the person managing the Airbnb and say, hey, you've got this dog running loose, we were hoping that that person then would be responsive and address that issue, because obviously, but if they don't, the sheriff's office will be responsive. So leash law or the sheriff's office are kind of our options there.
what was the second question?
So the next one was again about pets. And then when is an Airbnb? Is it forever or is it just when it's rented out?
If you look at the definition, the part when they rent that out to somebody other than the resident, and they're renting it for income, or they're renting it for compensation, that triggers the short-term rental use. So if it would be the determination, because you're not compensating yourself to come down and stay at your own house, that would then just fall into a regular residential use. They would be able to act out just like their neighbors would be, but that's their, at that point, it's not a short-term rental. So it deals with when they rent it out for compensation and it's advertised on one of these sites. That's a short-term rental. When you're staying in your own home, that's not a short-term rental. So I believe what was,
Yep, so then the next one, if you're ready.
Yeah.
The next one is, sorry, I'm going. The next question was, does everyone have to reapply after this ordinance is adopted, essentially? It's all.
yes. So the answer to that is no, because those in zoning, if you have vested rights in a decision that was granted to you at a certain time,
If permitted.
if it was a permitted use, you would have what's called legal nonconforming. Just like somebody had a gas station in a residential district, you could never do that now necessarily, but you would have vested rights because it was allowed at that time. In this case, if somebody had gotten permission, if they have a permit, a zoning permit that's valid now, they would be bound by the conditions of at the time that they received that zoning authorization. What people that are not grandfathered or have legal non-conforming status are people that are operating without a permit. So if those people operating without a permit come in tomorrow morning, and if this board so chooses to decide to adopt this new ordinance, they would have to comply with the new ordinance requirements, not the old ordinance requirements. If they came in today, they would technically get to, they would be able to operate under the old ordinance requirements. So any party that does come in after this date, it has to do the new one, and anybody that was operating prior to that. Now, there's a lot of people there's probably some people out there that aren't properly permitted, and we're gonna probably, they may get notifications to come into compliance. So, as we move forward, we'll act just like any other zoning violation and act on it. And there's stiffer penalties for operating without permits. That's been increased quite a bit over the old ordinance. So hopefully the folks that the numbers that have been previously permitted would, I think we're finding that the people that are operating and not operating in a manner that we would wish they would, probably there's a good number of those that aren't permitted. I would say the large number of somebody, just knowing a little bit about human nature, if they're going to come in and go through the trouble to get a permit and go through a legal process, they're probably going to care more a little bit about how their operation is anyway. Those that just buy a piece of property and think they can operate it without any rules are the ones that are probably going to be the egregious offenders anyway. That would be my opinion anyway. So.
Well, Dave, if I may on that though, because a point that I think is important that we wanted to talk about, and you and I am preparing for this, is that the current language still says that the use shall not generate additional noise, light, or traffic.
That is correct.
So, and that's an important tool. And since we're complaint based, until we receive the complaint, we're not aware. But if those complaints are occurring, for example, excessive use of the road, that would be, residential, you'd expect 1 or 2 cars, but if we're seeing literally 30 in a 30 to 45 minute period coming and going, that could potentially be a violation, and we could address that.
Right.
Okay.
Right. There are some rules in place to try to cap some of the bad use on even as the ordinance was written 5 years ago, that would cap some of that. We have some tools in our toolbox going backwards too. So in time.
So I'm gonna hit the last few questions here. So next was the restrictions on septic. The gentleman pointed out, but even though they only have 2 bedrooms, but they're renting it, saying 6 people or 8 people can sleep in a 2-bedroom. And I think if you could explain, I thought that was addressed with the VDH requirement. I thought that was the reason we added that language.
The VDH, whenever bedrooms are calculated, they allow 2 people per bedroom. That's their calculation standard. So technically, the number of people should coincide with those bedrooms. If you have 3 bedrooms, technically 6 people. So just That's how VDH calculated. Now, just like any other, it's a engineered, those systems are based on flow rates. Whenever you engineer something, we know that just like your automobile, you don't drive it at 6,000 RPM all the time. You drive it at 2,000 RPM. Maybe for a brief minute, you could go out at 6,000 RPM and run it. But it's the same way with a septic system. Overnight, it may be able to take some extra folks, but not on a continual basis where you have a 3-bedroom septic and you're operating it constantly like a 10-bedroom septic. It's going to fail. And that's what we want to try to, when people come in for zoning permits, it's going to be indicated in the conditions that VDH recommends 2 people per bedroom, and that's kind of what your guidelines are. I think it's difficult for staff to count heads going into a house. That's a really tough thing to do. So we think with this VDH requirement, you'll see a lot of these folks, and we've looked at them on our as we've researched these. They're advertising 4 or 5 bedroom homes, and we're looking and we're kind of going through our records, and they're permitted for 2 or 3. And we have weekend warriors that get in there and they build out above garage space without permits or authorization. They add bedrooms over time. And some of these folks may be in for a rude awakening when they thought they bought a house it's a 6-bedroom and they're only really rated for 4 or 3 or something. So they'll be throttled back to that limitation. So, and if they want to increase any usage of it, they're going to have to go through the health department, make sure that septic's adequate to accommodate it.
So that helps us to address 2 concerns. One was our concern with the Chesapeake Bay Act in Deltaville, which is where we see a large number of these occurring, especially I call them the old cement block cottages, 2 bedrooms, and now they're like four bedrooms. We don't want that runoff going into the bay. So it's a twofold. That was our attempt there, was to address the environmental concerns and the safety concerns, to be frank. That was the other component staff and I talked about. So the next 2 questions, one I'm going to go ahead and knock out, which is the realtor's claim. I'll keep my comments to myself, but I'll just simply say that they're not an attorney, and that's not a binding. These have been around since 2018. I would like to point out, though, as Dave said, what's interesting with Airbnb at the legislative level on the state is what got very far this year and almost passed, because it was presented on both chambers, was if your Airbnb is managed by a realtor, none of these regulations would apply. Just an interesting little caveat I thought I'd share. It got very far, and at the very end, it died. But it's the furthest we've seen on the local government level Airbnb be successful in its lobbying to deregulate from a local level perspective. But we have been seeing this routinely each year, and it gets further and further. And this is the first one that we saw in both chambers present identical language. And that was very alarming for local government. It would even take away like building code. It really limited us. Just think basic safety, regardless of how you feel about it. We wouldn't have been able to say, hey, you went from 2 bedrooms to 4 and all of a sudden, and let's check that out. It was alarming. So the last one was about parking spot. And I think we've addressed that, which is if it's 2 bedrooms, you have to have 2 parking spots. So if there's more parking occurring than that would be a violation of the old ordinance and the new ordinance. And that was one of the things the Planning Commission wanted to address. So if I have 2 parking spots, but I've got 8 cars parked.
I think there again, that's a little bit hard to regulate. I mean,
if it's there for a whole weekend.
Yeah, if it's constant, possibly. I think the intent of the ordinance is to keep that parking from bleeding over onto the neighbor's property. That's what we've heard, that complaint where we just don't have enough parking on our property, so we don't care, we're going to park on yours. That doesn't work. That's not acceptable. So if you can't find parking in the areas that we've designated in this ordinance, then you need to rethink your model as to how you operate this, because it's not reasonable to think that you could utilize somebody else's property or at least be offensive and park out, use up somebody else's front, even though it may be right away, to utilize all their potential on-street parking that, you know, you might have your friends or neighbors come and park in front of your house. You know, the ordinance, you know, says that's a minimum that you need to have as far as parking, you know, that number per bedroom, that you need that to have, you know, at least have that much. If you had more, I mean, that's okay, but you have to have a minimum of that. Just like any site plan may have a minimum parking requirement for a retail store. And it doesn't mean you can't have some extra parking, but you got to have X number of parking places per square footage of use. So, you know, if they had a few extra parking places, you know, if they utilized other areas in the lot, that's okay. It does mention that you can't park in the front setback, which in most areas that our citizens are living in residential areas where this is an issue, that's about 30 to 35 feet. So unless you have an existing driveway, you can park in a driveway. So we tried to, if you have to, you may have to park it up beside the house. So it's not as obtrusive looking as park, you know, having a front yard full of, you know, you look like you're having event parking with a bunch of parking in your front yard. So, and there again, if it's excessive, you know, that's part of the complaint process. You just, we've already started thinking out and hashing out how we're going to handle complaints and how they'll be routed and addressed and that type of thing. So. Anything else?
That was all.
Thank you, Dave. And thank you for good questions. I think those were informative to me, certainly. I'll open the floor for discussion and we can just go down the line if you'd like.
I would just like commend the fellows and women that are here because you're concerned about your community and where you live and what's going on. You know, because you're here, you're concerned. But I would just like to suggest, you know, it may not help, but try. You know, whoever's doing the Airbnb, let them know about your concerns in the community and let them know that hey, we have a good community here, and we want to keep it like that. And what can you do to help us out with this community? You know, if you know, and let them know about your complaints, because if they don't know about your complaints, you know, that's when problems can occur. So that's all I can encourage you to do, because you know we're putting in some things in place, but sometimes it may not work. It may not work because I'm just being fact. You got a lot of idiots in the world. I'm just saying that, and sometimes they won't listen. You know, they won't listen. You know, you can sit down and talk to them nicely and everything like that, but you know, you'd be better off talking to a tree sometime. But at least you can try and say, I made that attempt. And we as county officials, we're gonna try to do the best we can because we're still tweaking different things that we hadn't foreseen that's coming because, you know, in 2018, you know, this started coming and we tweaked it a little bit. Now we're doing a little bit more. I know, I think it was John said something about fencing, you know, and we did mention a little bit about that because like you said, you got a dog gonna go anywhere you want to go, you know. So, you know, we're trying the best we can and we're still gonna have to be doing a lot of tweaking. But I commend you from coming out here instead of being in your own home, fussing and complaining, and nobody doing them. But you know, the squeaky wheel gets a lot of attention, and I appreciate you all for coming out here. We thank you all for listening. We'll move this way,
So maybe you can see me. In talking to some people about this particular issue over the last several months, people would say, well, you know, they do it like this in Virginia Beach, or they do it like this in Nags Head, or they do this, and why don't you do this? My point to that is this. And my comment to all those people was, I don't care what they do in Nags Head. I don't care what they do in Virginia Beach. I don't care what they do anywhere other than what they do here in Middlesex County. However, there's some things that go on in some of these other larger vacation type spots that we as a board have recognized that some of that stuff may be coming our way, and how can we control it and what can we do about it? I'll commend everybody that's worked on this particular thing, particularly Mr. Kretz and particularly our attorney, in trying to put some teeth to be able to regulate what we need to regulate. Again, thank you for coming today because, and I say this quite often, I know what I know, but I don't know what I don't know. Now, most everything that was questioned today or asked, I know a little bit about most all of that. However, there was one thing that was said that made an impression with me, particularly about fencing, that I hadn't quite thought about as much. And I'll be thinking about that a little more. I just want to assure you this. And I think you, sir, the first guy that spoke, made reference to you had asked some questions and you hadn't got, or maybe it was the second guy that spoke, I'm not sure. Yeah, second guy, my bad. That you should get the answer to any question that you ask, and you have a ton of resources to get that from a variety of people here, from the county administrator to the assistant administrator to who your board representative is, to the attorney, to Dave Kretz. All those people will provide you answers if you need it. I feel pretty assured of that. And we're here. The landscape of our county is changing. And we're trying to be as progressive thinking as we can of what we want it to look like over time. And what are the high sides and the low sides of what may be coming. I've lived in this county for 40 years, and in some cases, showing my age a little bit, maybe we weren't as concerned about what's coming next. I can assure you that this board is very tuned in to what's coming next and what do we need to deal with and how do we need to deal with that. Again, thank you for coming because your input is important to all of us. And we will hopefully make the right decision, at least from this ordinance from 2018 to where it is today. There have been some teeth added to that. But like anything in any change, it's very difficult for you to make a sweeping change right here today that without a crystal ball, knowing how that's going to affect anything that goes on with the decision that you make. We try to well think that out, and we try to cover the areas that we need to cover for trying to understand what that may or may not mean. But we are here for the county and for what's the best for the county. And mentioning the ordinance from 2018 to now, I wouldn't bet a nickel that it won't change again over some period of time. We'll feel this out and see how things are working and what complaints we're getting. And if what we're proposing to do doesn't work or needs some improvement, I can assure you that this group here will look at what it needs to make that change and to do it that will protect the citizens of Middlesex County. Thank you again for coming.
Mr. Koontz, if you're still on, do you have any comments?
No
He is,
comments.
around. He's on the other side of the globe in Nepal right now, so
No
there's a bit of a
comment.
delay, but thank you, John. Mr. Williams?
Well, echoing what John and Brother Jesse is saying, and I believe that this is Middlesex County, and this ordinance is a start. And a little change, but you all help us make a difference because you are our eyes out in the county. And you bring it to us because it only don't start with corporations that are buying land and buying houses and renting BB&Ts out early. It's only don't start. See, some of us do the same thing that stays here. We got B&Bs and we are renting them out. Some of us is a problem. But make us aware like what you all are doing tonight. And that's our blessing, because I can tell you about one thing with this board, and this is my first term. We're here to help you out. We believe in Middlesex County, and we believe in the things we'll do together. We're great. Separate, we are nothing. So what I'm saying, keep on doing what y'all doing. And y'all know all our numbers from administration, planning, and I heard some of y'all speak before and stated, I can understand what y'all saying. I really can understand what y'all saying. And we can make it a better place to live. We don't have to listen at all of these, we were young one time, and we gotta kind of like a way, we gotta reach out and touch them in a way that, look, y'all too noisy. We gotta look at ownership and let them know, let us be aware so we can call. And together we can do this. And once again, I like y'all coming forth and spending y'all time here, and we are listening. We hear what you are saying. From administrator, planning commission, we hear what y'all are saying. They worked hard on this because I was with the planning commission too, and they worked hard on this. But some questions are so good. You got 3 cars and you got 15 people in the house. I know what y'all are talking about because that's how they come. They don't come with everybody driving a car. If they find out, they're gonna find a loophole to go around. Now we're living in a time that we got these cameras that do anything you want to do. All you just put them onto your house. You put one onto your house, you can monitor any traffic going down your lane anytime you want. Then you got something you can give over to our lawyer, and she got something you can go to court to because you can ask them, you can plead with them, you can even use documentation saying I went and talked to the ownership. But once you show that video, you don't have to say a word. And I'm not exactly telling you how to do, but we do have these videos. We have these videos now that we can record. Our video is our witness. So you don't have to come and say, I wonder what he was telling the truth or not, right? Now I gotta stand up and find out, he won't tell the truth. These videos, I'm telling y'all, I know they will work. You put it up there and you come and you go over to our lawyer and we look at these videos and then all of a sudden, we can make something happen together. We keep on working on what we want and this is a great start. This is a great start for all of us because they're coming, but we're ready, so God bless y'all.
Thank you, Mr. Williams. I echo what everyone else has said and am really glad you're here. I think all of you are in my district in Deltaville, and we know that Deltaville has a lot of weekend traffic, and I'm well aware of that. One of the challenges that we have as a rural community is, of course, enforcement. And for that reason, I would speak in favor of the recommendation that any complaints received must be responded to within 60 minutes of being contacted. I think that in itself is probably the most powerful enforcement tool that we could enact. I've been on the other side of that where I had a complaint and it was not here, it was elsewhere where they were required to respond and they did get the response that quickly. And so my recommendation is that we enact that, but otherwise I think that this has been well thought through and it's a really good start for us. Any other discussion?
So, are we at a position to make a motion on this?
With or without the recommendation also?
I will make a motion, but before I do that, I'll ask this. The 60-minute of being respond, attempt to resolve any complaints received within 60 minutes of being contacted. If, let's say it's, I don't care what number you want to use, let's say it's 3 hours or 4 hours or God forbid, 24 hours after you receive a complaint is received, does that put them in non-compliance of the ordinance if they or at some time frame later than that?
Yeah, we were just confirming. We think so.
Technically, it does.
Yes.
Technically, it does. Yes. I think there's, if we go up, I think that subsection, any of the, I believe it, any of those subsections above would be would be a violation of any of the items above. It's kind of a catch-all at the bottom of this without, where was it at, Heather?
Yes, sir. It's right there. That's exactly what you're thinking. So
Yeah,
that
right at the bottom there.
we drafted this purposely very broad. And because the planning commission was very clear, this is a revision, the last sentence here that we added to further clarify. This is a larger financial penalty than we typically have. And number two, I drafted it so it encompasses all of 1529. So whether that be you fail to respond within an hour, now obviously there could be, we're in the middle of a hurricane and they could, you know, I mean, I want to give that caveat, do the lawyer thing there, but if they're habitually not responding, that's absolutely going to be a violation. And so that's something that when we receive the complaint and it's investigated and if it's substantiated, our enforcement officer gives it to me. He swears out a summons and we go to court and I prosecute. So essentially that's your strike one. And then if it happens again, I've got a strike two. And now we're going to pull your permit. So now I'm going to court not only for a violation of that, but I'm going to court because you're operating without a zoning permit. And the Commissioner of Revenue is going to be notified and she can bring enforcement for failing to operate without a business license if you continue to do so for your permits. So we've really tried to hit it from multiple agencies here. So yes, sir.
Thank you. I just wanted to make that clear on the public record that that's where it was, but thank you for the explanation as well. So with that in mind, I would make a motion that we approve the ordinance amendment 2022-2 in addition to and I don't see it in front of me,
The staff recommendation.
and the staff recommendations for callback.
60 minutes.
Yes, for 60 minutes. I'll make that motion.
I'll second it.
Motion by Mr. Harris, second by Mr. Jesse. Any further discussion? Roll call, please.
Mr. Coons,
Aye.
Mr. Harris,
Aye.
Mr. Williams,
Aye.
Mr. Jesse,
Aye.
Mr. Kimbrough.
Aye, motion carries. Thank you. There, let's see, we don't have another public here. So I will entertain a motion to adjourn.
So move.
Second.
Motion by
Yeah,
Mr.
I wish I
Jesse,
had some-
second by Mr. Harris.
They're downstairs. I can go get them.
Roll call.
Harris,
Aye.
Mr. Williams,
Yes.
Mr. Jesse,
Aye. Aye.
Mr. Coons,
Something tells me
Mr.
you don't have to tell
Mr.
him twice.
Kimbrough.
Aye.